Trump versus Casa. It involved what are sometimes called nationwide injunctions, but which the court called universal injunctions. If you are doing something horrible to me, I can get an injunction against that, and that injunction can be effective wherever you are. That's nationwide, and that's fine. But the injunctions that were being complained of were injunctions that were not just in favor of the plaintiff bringing the case, but in favor of all sorts of people who were not parties. This particular decision is a classic originalist decision. Not all of them are, but this is one in which Amy Coney Barrett, who wrote the opinion for the court, actually went seriously into materials that the founders were familiar with and the founders, in fact, were involved with. The authority that was claimed to grant these universal injunctions came from the Judiciary Act of 1789. Judiciary Act gave what's called equitable relief to the courts. Amy Coney Barrett's opinion very thoroughly points out that equitable relief, as it was understood in 1789, didn't include these universal injunctions. That that's not something the courts could do. The courts get their ability to issue injunctions ultimately from the Constitution, but immediately from statutory authority. And this statutory authority simply didn't grant it.
The United States Supreme Court has finished their session. What does it mean for Colorado? We're going to find out. But first, subscribe and like our channel. Click on that little bell icon for notifications. And find the Devil's Advocate podcast on your favorite listening app. From the Independence Institute, that extraordinary constitutional guy. Who the hell cares about the Supreme Court anyway?
Colorado better care, because Colorado officials have got this war going on against conservative religious groups. And they've already been struck down by the Supreme Court several times, and in other cases going up. And this term confirmed that the majority of the Supreme Court, in fact, all 9 justices, are very protective of religious liberty.
Even here in Colorado.
Even here in Colorado.
All right, let me ask you the larger question. Every time I hear something about the Supreme Court, United States Supreme Court, I hear about the conservative majority on the Supreme Court. The conservative majority again voted 6-3 on ideological lines. I always hear this, on ideological lines. So how lockstep is this court as a conservative, liberal 6-3 majority?
It's not lockstep at all. I don't know why the media have been portraying this narrative of the 6-3 conservative majority, but it doesn't exist. And this term was a good example. In the last,
what do you mean it doesn't exist? I keep hearing it.
You keep hearing it, but it's simply not a reflection of reality. In this particular term, there were, I think, 62 decisions. Only 9% of them were decided by this legendary 6-3 figure. The rest of them were unanimous, or the court was split in other ways. And there were a number of important decisions where a liberal majority made the decision with only a few judges dissenting. So the bottom line is that for whatever reason the media are portraying this narrative, it simply is not an accurate portrayal of what the court is doing.
How does that compare, that 9% to years past? So are we getting more unanimous, more 6-3 conservative rulings?
It's a little down from last year. Last year there were about 13% of the decisions were by this supposed 6-3 conservative majority.
Well, would it be fair to say that maybe more, obviously, overwhelmingly, most of the decisions are not 6-3 conservative majority, but on the key ones, the important ones, the abortion ones, that these guys just lock together?
No, on the contrary, John. There were some very important decisions that have implications for the deep state, for the administrative state. That is to say, they tended to call off the trend of decisions that limited administrative power. They were decided by majorities of 6-3 or 7-2 in favor of the liberal side. Also, there were some other cases, including one, for example, on religious liberty, where the opinion was 9-0.
Let's talk about that one. Which one was 9-0? What possible issue could make it all the way to the United States Supreme Court and get struck down or at 9-0?
The state of Wisconsin offered religious exemptions to religious organizations such as churches.
Exemptions to what?
Well, exemptions from income tax for property tax. The the Catholic Church applied for an exemption and essentially was turned down because of its doctrine. The Catholic Church had the position that its charities would be given to everyone who applied, not just Catholics, and would be given without proselytization efforts. The state of Wisconsin said that unless you limit your service to Catholics or engage in proselytization, then you are not using the property for a religious purpose, and we're not going to give you the exemption. So the Supreme Court, in a unanimous opinion, said the most basic message of the Establishment Clause, one of the religion clauses on the First Amendment, is you cannot discriminate against or among religious denominations. And they were doing that because certain Protestant denominations would have qualified for the exemption.
So in other words, if the Catholic Church and their Catholic charities, and the Catholic Church does a ridiculous amount of charities. Here in Colorado, Catholic Charities takes care of homeless and foster kids. I mean, just if those organizations said, we're going to give you that charity, but first we're going to tell you about Jesus Christ and from the Catholic point of view, then they would have been fine.
Then they would have been fine.
My brain doesn't wrap around that. So
even their argument was that if you're simply giving out charitable aid, you're not engaged in a religious purpose. I mean, that was a position of the state of Wisconsin, and it's hard to maintain a straight face while saying it because, of course, giving
is a core tenet of the Catholic Church.
It's a core tenet of Christianity. It's a core tenet of Judaism. It's a core tenet of Islam. It's very much identified with religious activity, Hindu religious activity also.
Since you mentioned Catholics, isn't the Supreme Court overwhelmingly Catholic? I mean, I don't know how much of the United States is Catholic. Mm-hmm. Not that much. It is mostly Protestant, if religious at all. And I think more Americans now are secular than they are religious. But isn't the court just have a ton of Catholics?
Good question. I haven't counted it recently, but I think there were 6 or 7 Catholics on the court, 1 Protestant, 1 Jew. As a Jew, I complained that that's underrepresentation. In fact, I complained about it when there were 4 Jews on the court, that was underrepresentation.
So doesn't that skew? Isn't that something that you look at and go, well, how? Of course they're going to find in favor of the Catholic Church. The majority of them are Catholics.
Well, yeah, but they're different kind of Catholics. I mean, Justice Thomas is a Catholic and Justice Sotomayor is a Catholic, but they're very different. They have very different philosophies. However, I will say that if I had been the counsel for the state of Wisconsin, I would have advised the administrators or the legislatures to change the rule because they're going up with a case that denies benefits to the Catholic Church before a court that is majority Catholic. That's just bad litigation strategy.
But it was still a unanimous decision.
It was a unanimous decision.
Right. And so when I hear the conservative court or on ideological lines, it's not like they were wrong, are they, when they say on ideological lines? Or if it only happens 9% of the time,
the difficulty with that, John, is that among the 6 people that they identify as, quote, conservatives, and I would say really are better described as traditional judges, because we've had conservative activists on the court before. We don't have any now.
Would you put Scalia in that category?
No, well, maybe a little bit, but actually, I think probably the last true conservative activist on the court was Justice McReynolds, who retired back, I think, in 1941. So it's been a long time since there's been someone who's willing to skew the law to achieve conservative results in the same way that we've had liberal justices do that. Now, among those 6 people that the media identify as conservatives, they have very different judicial philosophies. There are strict originalists like Clarence Thomas. There are modified originalists like Alito. There are people that I would describe as accommodationalists like Chief Justice Roberts. Yeah, right.
I would use the legal term squishy.
Well,
because I have a sense that Roberts does one of these, tests the wind out, and says, no, the feeling amongst America or amongst the elite in D.C. is this, therefore Obamacare is legal. Even though if he were just left to his own devices, go, no, this is not.
I don't know if I would go quite that way. I think he sees his role as preserving the state's political capital. But being very much a man of the District of Columbia, he tends to think within the Beltway terms,
Right.
and sometimes overlooks the fact that you can damage political capital with everybody outside the Beltway.
When you say political capital, you're talking the courts.
The court's political, yeah.
So
the
Roberts is very concerned about the reputation of the court,
Right,
and that,
because
America sees it as a distinct branch that is not influenced by politics.
And you mentioned the Obamacare treatment by the court. That's an excellent example, John.
I only use excellent examples.
And by the way, I'm honored to be here. At any rate, there was yet another case this term in which the court bailed out Obamacare. And this was by a decisive liberal majority, and it involved a clause of the Constitution that determines who can appoint federal officers. The court went through, in my view, various contortions to uphold a scheme that Obamacare had imposed that looks on first glance to be unconstitutional.
Which one? Give me some meat on that.
Well, there's an organization within the Department of Health and Human Services that reviews preventative care measures. And Obamacare took this commission, this body, and gave it enforcement powers effectively, so that every insurance company in the country must cover the types of services that this
unelected group does.
Exactly. And so under the circumstances, a party sued and said this body should have been appointed by the president. These people are really what the Constitution implicitly calls superior officers, heads of departments, and should be appointed by the president. The court concluded they're not superior officers; they're inferior officers, and therefore Congress can decide to have them appointed by the Secretary of Health and Human Services. And then the question arose: well, did Congress really give the Secretary of Health and Human Services that power? And the court went through all kinds of contortions and stretching of the statutes to conclude that it did. Again, the effect was to uphold Obamacare against one of its many constitutional infirmities.
And those who voted for that included a couple of the so-called conservatives.
That's right. The vote on that was, let's see,
checking notes.
Checking notes was 3-6. That is to say, Roberts voted with the liberals, and Kavanaugh and Barrett all voted with the liberals.
Interesting.
And that's not unusual. It's very common. It underscores my point earlier about
they say the conservative justices versus the liberal justices. Would it be better to say the Republican-nominated justices versus the Democratic-nominated justices? Would that, because I think of, why is that when Republican presidents put guys into the Supreme Court, they drift left? I mean, David Souter being a beautiful example. I've never seen a Democratic president put in somebody who then finds his way to the strict constitutionalist point of view and angers the left. It always seems the drift is always one direction. But it doesn't mean they're conservative. It just means a Republican president put them in.
Yeah, I mean, you identified the reason why that's not much of an improvement. It's a little bit of an improvement, but it doesn't tell us much because, as you say, Republican nominees have this history of drifting left. I mean,
why is that, by the way?
Legal scholars have asked that question a lot, and I don't know that there's been a determinative answer to it. I think that there are different reasons for it, but certainly the pressures of living in the District of Columbia, especially if you want to go to cocktail parties, the incentives are in favor of moving left. But it has been a major, major phenomenon. I mean,
if we moved the Supreme Court from D.C. into Omaha, Nebraska, over time, we would see a change in the same way that legislators from around Colorado come to Denver for 120 days a year, and it's like sending your kids to Berkeley or up to Boulder for college. Over time, they change because it's part of the culture there. They're in an urban area. They're around lobbyists all the time. They're going to the cocktail parties all the time. They're not back where they come from.
Actually, I agree with you 100%. I mean, my personal candidate for the location of the Supreme Court is Salt Lake City. I don't understand why the Supreme Court of any jurisdiction, whether a state or federal, has to be located in the same city where the legislature is located.
Right.
There are just too many conflicts. I think that ought to be at the state level too, that Colorado, for example, should consider maybe moving its Supreme Court to Colorado Springs. It's not exactly that one city is liberal or the other city is conservative. It means that being located, living someplace else, gives you a measure of judicial impartiality that you might not have if you're constantly rubbing shoulders with the political class.
As a complete aside, I support having congressmen and even legislators be able to telework, and that if you are in your home district where people can knock on your door and you're going to run into your constituents at the grocery store, it's a whole lot different than when you're wined and dined out in D.C. by every special interest. All right, let's get back to some of these rulings. One that really caught my eye was on parental rights. Actually, I guess it was more on religious rights than parental rights, saying that parents have the right to say in a school, no, I don't want my kid reading that book that indoctrinates them into the trans movement or whatever. What was the case? Who were the plaintiffs? Because I thought that was interesting.
Mahmoud versus Taylor is the case. The lead plaintiff was Muslim. And there was also a Jewish plaintiff and a Christian plaintiff.
Were the Muslim and the Jew going at it the whole time? Were they
all on the same side?
Were they slapping each other on the bench? No, they were.
And so,
which by itself was interesting, because usually when you think of these type of cases on, I don't want my kid to hear about this, it's always the Christian, it seems. Here it was split across an interesting group.
I think that's a popular misconception that the only social conservatives in the country are Christians. I mean, you have a huge Orthodox Jewish population, and Muslims tend to be perhaps more socially conservative than either Christians or Jews, although I'm not an expert on that. This is a case where a school district had reading materials and programs that promoted the gay, lesbian, queer, transgender agenda, and refused to give any notice to parents as to when this would be done, and refused to allow parents to have their kids opt out. For example, the program celebrated gay marriage. Well, traditional believers of all three religions believe that only in heterosexual marriage. And so, getting no satisfaction from the school district, they eventually sued, and the Supreme Court said it's a violation of the First Amendment to essentially cram anti-religious propaganda down the throats of kids over the parents' political objection. By the way, John, this was actually only one of several cases in this term where the court took what could be described as a pro-child position, where the court reached conclusions that were protective of children.
Well, that's subjective, right? That you're saying it's protective of children. I'll go to the queer activists who go, no, we're helping these children learn about themselves and all the other good stuff. But the question is, whose kids are they? Are they children of the state, or are they children of parents? And I believe they are children of parents, not children of a state.
And
they're not Hitler Youth.
And that has been formal Supreme Court doctrine now for over 100 years. That children are not creatures of the state; they're the treasured offspring of parents.
So this ruling affects Colorado specifically because Colorado has this curriculum advisory committee, or it might even be by law, that has been pushing an agenda that are part of the curriculum in grade schools. Or Pam Benigno at Independence Institute has been working to get people to understand that 6-year-olds are getting books about transgenderism and Harvey Milk and gay rights and all the rest before they even have a sex ed class.
Right.
And by the way, I think this is good history. There's a book, they talk about Jared Polis being the first openly gay governor in the United States. I think that is legitimate to know. I think it's legitimate to teach. I think it's an important thing. But if you're 6 years old and somebody says, oh, it's the first gay governor, and you're 6, your question is, what is gay? I don't know what that is. Yeah. And don't you have to then talk about sex first to get to there? And you're not going to talk about sex for several more grades.
Well, this is not a constitutional observation, but given the record of the schools in recent years in teaching such core subjects as math and history and reading, you wonder why they feel compelled to go into these areas. But the important point here is that this is the kind of decision, appropriateness or not, that should be made by the parents. Over 100 years ago, and I alluded to this a minute ago, the Supreme Court said that parents actually have a constitutional right to direct the upbringing of their own children. Now, this was not at issue in Mohammed versus Taylor, but it could just as well be. And when regulations or school programs are designed in a way to undermine that parental right, then you're going to get pushback from the Supreme Court.
The Supreme Court rules now that parents can opt out of this. This was a traditional 6-3 Republican nominees.
That was 6-3. There's also an interesting case, a Free Speech Coalition case, which involved a Texas law which would require moderators of pornographic websites to verify the age of the people who were watching. And the Supreme Court upheld that Texas law. Again, it is in common with this theme of protecting children. So,
and what was that? Was it the same 6-3?
It was the same 6. That's right.
All right. So you got prudes versus cool people.
Yeah. Remember, both of these are important cases. But remember, this kind of 6-3 decision is only 9% of the cases that the court decided. But they are important cases.
I want to get into that one just for a little bit. I've got mixed feelings on that Texas law.
Yeah.
That once you start having some third party becoming liable for being a nanny, for taking over parental rights, which is, it's your job to now become the parent and make sure your kid's not looking at naughty stuff, then all of a sudden you've got these warehouses, these data warehouses of personal information. You got to submit some sort of ID, you got to do this, you got to do that. It forces people to to make their lives more vulnerable. Although I know porn sites are probably some of the safest sites you can go on for digital security, still people might want to go, no, I don't want to give you my ID. I don't want it to end up on the dark web. Furthermore, it's not like the school library or the local school saying, here are the books pushing an agenda. The internet is everywhere and nowhere at once. So I don't know how you get a company based in Guatemala to keep with a Texas law. It doesn't seem a workable thing.
Yeah, I have not studied the law to the extent that I can give you an opinion on it.
But I've studied the porn sites.
Right, yeah, sure. But as a matter of constitutional doctrine, the court said that these sites are pornographic for adults, but for children they rise to the level of obscenity. And the position of the court has always been that obscenity, more serious than pornography, these sites include videos, for example, of men raping women, that what is obscene can be banned entirely. It's not protected by the First Amendment. So that's the division that the court is making. You've got pornography, which is protected by the First Amendment for adults, and you have obscenity, which is not protected by the First Amendment. And sometimes the same material that's merely pornographic for adults can be obscene for children.
But the law is that what is obscene for adults can also be banned?
That's right. Obscenity can be banned. Obscenity is outside the protection of the First Amendment entirely, although the test for obscenity is pretty difficult to meet. I mean, it's got to be pretty.
Isn't the test for pornography also just difficult to choose or to describe?
Well, yeah, a Supreme Court justice famously said, "I don't know."
I can't describe it, but I know it when I see it.
I can't define it, but I know it when I've seen it.
Yeah.
And
which doesn't work in a law book,
right.
does it?
And that's why I think one reason why the court decided that pornography is protected by the First Amendment. Obscenity is a little easier to define, although the test is more amorphous than I would like.
That First Amendment is tricky in that there are several rights built into just a couple of sentences.
Yes.
Let me see if I've got them all. I think there's like 6 or 7. There's that the state government cannot establish a religion, that people have the right to exercise religion, that people have a right to free speech, that people have a right to petition the government, people have a right to peaceably assemble. Was there one more? I'm trying to...
Press.
Oh, yeah, well,
freedom of the press.
Freedom of the press, of course, freedom of the press.
It's very good, John. One we overlooked, the freedom of association is not in the First Amendment, but is viewed as implied by the free speech and free press rights and has been ever since the founding.
But wasn't there a freedom of assembly? Was that what it's called?
Assembly. Yeah.
Assembly. And by that we then infer that there's a right to freely associate with people you want.
Because you can't, for example, set up a newspaper without people associating. You can't you can't have a party. Petition.
You can't petition without people assembling. Right. All right, so you got all that glommed into just a couple of sentences, which is masterfully written. And this case that we're talking about on books especially, that wasn't about freedom of assembly. It wasn't really about freedom of press. It was about freedom of religion. Or was it more about establishing a religion?
I think it's more like free exercise because the court has said the ability of parents to guide the religious instruction of their kids is part of free exercise. And so if you've got these kids who are at school learning stuff that contradicts what the parents tell them in their religious instruction, then that interferes with the free exercise of the parents.
What else did the court do this time that got your attention?
Yeah, there's Federal Communication Commission versus Consumer Research. This is another 6-3 decision, but it's one that the liberals won. If you have a landline and you look at your phone bill, you'll find something called the Universal Service Charge. I checked mine. Mine is about $4.41 a month.
And this is for your landline?
Landline.
Because you are 93 years old and still have a landline where nobody else does. Right.
So it's $4.41 a month, and it has tripled in the last decade. This is effectively a tax, but it's not a tax levied by Congress. It's a tax imposed by an administrative agency, the Federal Communications Commission. And the issue in this FCC versus Consumer Research case was whether this was an impermissible delegation of legislative power. The Constitution says the legislative power is in the Congress, not in the executive branch.
And the power to tax
is considered legislative, right? And so plaintiffs challenged the charge, saying that this is an unlawful, unconstitutional delegation of power. But the court upheld the FCC's exercise of that authority.
Really?
Yes.
I'm surprised and disappointed by that.
Well, it's one of several decisions where the court slowed down its even slower progress toward reigning in the administrative state. And it's an excellent example of how a 6-3 or a 7-2 liberal majority can often be assembled on this court.
And so I'm assuming the 3 democratically nominated justices voted that the regulatory state has the power to tax us. Who joined them?
Well, the Chief Justice.
Of course.
And Barrett and Kavanaugh.
Wow. I'm disappointed. You think a guy who drank that much beer would keep an eye on his
Just
pennies?
to clarify, there's no question that Congress can delegate some power to the executive branch, and it can even delegate some revenue-raising power. So, for example, it could say to the president, under certain circumstances, you can impose a tariff of no more than 5%, and they've done that. The problem with this particular charge is that there was no maximum percent, there was no maximum of revenue collected, and the scope of the services for which the charge was imposed was largely, I would say, practically in control of the FCC. And so the FCC keeps expanding this level of the services and therefore expanding the tax necessary to fund them.
Speaking of the right of the...
Oh, go ahead. One quick example. The FCC apparently has now mandated that there must be wireless internet in school buses, okay? And to pay, and this tax goes partly to pay for that.
So my phone tax goes so that some kid can watch YouTube and play Angry Birds on the way to school.
Or TikTok, yes.
TikTok, yeah. All right. Lovely, just lovely. One of the things that has so many people have said is a ruling that says lower courts have a harder time enjoining executive actions. This is part of the, we got to stop Trump, we got to stop Trump. It was a huge victory for Donald Trump. What did that actually mean? What was the case? Because it's blurry to me.
Yeah, it's called Trump versus CASA, CASA, C-A-S-A, Trump versus CASA. And it involved what are sometimes called nationwide injunctions, but which the court called universal injunctions, because the term nationwide is a little misleading. If you are doing something horrible to me, I can get an injunction against that, and that injunction can be effective wherever you are. That's nationwide, and that's fine. But the injunctions that were being complained of were injunctions that were not just in favor of the plaintiff bringing the case, but in favor of all sorts of people who were not parties. This particular decision is a classic originalist decision. Not all of them are, but this is one in which Amy Coney Barrett, who wrote the opinion for the court, actually went seriously into materials that the founders were familiar with and the founders, in fact, were involved with. And specifically, the authority that was claimed to grant these universal injunctions came from the Judiciary Act of 1789. Judiciary Act gave what's called equitable relief to the courts. Amy Coney Barrett's opinion very thoroughly points out that equitable relief, as it was understood in 1789, didn't include these universal injunctions. That that's not something the courts could do. The courts get their ability to issue injunctions ultimately from the Constitution, but immediately from statutory authority. And this statutory authority simply didn't grant it, in her view.
All right, so of course we all look at this through political eyes, not legal eyes. And we go, this is a victory for Trump, and now he'll be able to do anything he wants, and the courts will not be able to stop him until it goes all the way to the Supreme Court. Is that true?
No, or at least it's no more true of Trump than it was of his predecessor. As you know, John, I've written on the record of the Biden administration, which is probably, by any objective measure, the most authoritarian administration in peacetime history. And of course, in that event, you had liberals and conservatives sort of on the other side of this. The court's basic point in this case was simply because something is wrong or unconstitutional doesn't mean we can intervene to stop it. In fact, we may not have jurisdiction to stop it. And the court cited Marbury versus Madison, the very first case of judicial review in the U.S. Supreme Court, dated to 1803, in which Chief Justice Marshall said, what Secretary of State James Madison did was wrong, but we don't have the authority to stop it. It's the same, it's basically a limitation on the judicial power. The judicial power is not some censorship power where you go around looking for things to stop, because it's constrained. It's constrained by all sorts of provisions in the Constitution and law.
Does this mean, for instance, it was on the issue of birthright citizenship?
Yes.
And people, I've heard say, oh, now people born here cannot become citizens. I think that is a simplistic rule, because what was at the heart of the case, if you are born here by people who are here illegally, are you or are you not a citizen? That still has to work its way up to the Supreme Court, doesn't it?
That's correct. And I think one motivating factor behind the court's decision, it wasn't stated exactly, was that this issue of birthright citizenship, the boundaries of it, really needs to percolate more through the court system. Percolate is Chief Justice Roberts' term. It needs to percolate more through the court system. In her dissent, Justice Sotomayor took the absolute position that if somebody is born in this country, then that person is a natural born citizen, period. And I do not believe that's a correct reading of the 14th Amendment. I don't think it's a correct reading of the precedents. Actually, you've got, in these birthright citizen cases, you've got people taking two extreme positions, neither of which I think is tenable. One position is the Sotomayor position. Darn it, if you're born in this country, you're a citizen. End of discussion. Again, that's not what the precedents and it's not what the 14th Amendment says. And then the Trump position is, if you're born in this country of a mother who's illegally here, you're not a citizen. I think that's right. But then the Trump position goes on to say, if you're born here of somebody who is rightfully in the country, but this is not your permanent residence, you're not a citizen. I think that's clearly wrong. So I think both sides have staked out extreme positions, and I think the court needs time, and we need more litigation to answer this question correctly.
Of course you think we need more litigation, because you're a lawyer.
Oh, yeah.
Lawyers don't like anything to come to a head.
I wouldn't have an opportunity to give you all this free service.
That's right. All right, let's do one last ruling, which I believe was unanimous, and it was surprising for a lot of folks on the left, because it had to do with someone who was fired or not promoted because she was straight, not gay.
Yes.
And this was fascinating in that it got a unanimous decision. Really said a lot. What was at stake?
Yeah, and the person who wrote it was Justice Jackson.
Right. Who you got to think is the most progressive of all 9 of them.
This case involved not the Constitution. It involved the application of the Civil Rights Law of 1964. Which had been interpreted by the court a few years ago in 2020 to include a ban on discrimination based on sexual identity.
Not sexual preference, but sexual identity?
Or sexual identities, right. Gender identities, and sexual preference. So this particular woman, her name was Ames, held a state job in Ohio, and she went up from the secretarial position to a middle management position. And then she applied for a senior management position. She was passed over for a gay man. And then she was fired from her middle management position, bumped down to secretarial in favor of another gay man. So she sued, saying this is a violation of the
I was a qualified person,
right.
but I wasn't gay.
Right, exactly. So she sued based on the Civil Rights Act of 64. The particular region of the country was governed by a federal court of appeals that took the position that if you were a member of a minority group, you had to prove certain things. If you're a member of a majority group, in this case heterosexual, you had to prove more. You had to prove not just the basic.
All right, so I find that, tell me if I'm wrong. I find that so offensive, that the idea of rule of law is that we are all constrained by the same rules of law. The president cannot go out and murder somebody. I cannot go out and murder somebody. Jeff Bezos cannot go out and murder somebody. If Jeff Bezos was straight, gay, or queer, it doesn't matter. He still can't go out and murder somebody. We're all subject to the same laws. That's, when we say equality, that's the equality of which I think our founders spoke. And so to say No, because you're of this minority group, you have a higher standard or a lower standard. That's just wrong.
Yes, and that's the position that the court took. It's wrong. It's not justified by the statute. There was a concurring opinion by Justice Thomas who pointed out there was another problem with the additional hurdle. The additional hurdle said that if you were a member of a majority group, then you had to demonstrate that your employer was one of those unusual employers who discriminated against members of a majority group. Now, number one, in practice, this had only been applied to white males, but white males are only 30% of the population; they're not a majority. And secondly, it is simply not true that it's unusual for an employer to discriminate against white males. Those of us who are in academia dealt with this all the time, you know.
Well, as somebody, my years as an elected official at Regional Transportation District, you saw minority quotas disguised in different ways. We have to do so many contracts to disadvantaged business owners, and it was racial quotas.
When I was looking for jobs, and I'm going to name names, I was invited to campus for job interviews by the University of Illinois and the University of Denver, and both of them avowedly said, "Rob, we're not going to go ahead with it because we're not hiring white males this year."
Well, and CU just went through this and got their knuckles rapped for it as well.
Yeah.
This is.
Yeah.
All right, so that a refreshing thing where we see all 9 justices saying, no, equality is for everyone equally.
That's right.
All right, that's pretty good. Was there anything that the courts didn't take on this year that surprised you? In other words, people ask, please, take on this case, and sometimes they don't, which frustrates people who want an answer to whatever issue it is. Anything big happen in that way?
I can't think of one exactly. I'd have to review the entire record of all the petitions for certiorari, but it seemed to me that the cases that the court did decide were ripe for review, and that's really one of the criteria the courts use in deciding whether or not they're going to hear a case.
What does that mean, ripe for review?
Well, it means that it's a real controversy between real parties. It's not a set-up lawsuit. It means that the issues have been thoroughly presented in an adversarial way. In the case of Supreme Court, it often means that this type of case has been through the lower courts, and there is a split among the different federal circuits on the issue. They may also, I suppose, consider the quality of the briefing of the case. Are these parties really going to provide the court with the kind of information they need? The court can afford to be selective. There are thousands of people who would like to get before the Supreme Court.
How many cases do people try to get in front of the Supreme Court, and how many do they actually take, usually?
I don't remember exactly what the number is, but it's well under 10% of those that they accept.
And when they don't accept it, it's just whatever the lower court says.
That's right. And often these cases will end in the lower court, and then you'll have similar cases that arise, and one lower court decides it one way, the other lower court decides it the other way, and then the next case that comes along might make it on to the Supreme Court based on that division.
And what happens when the 10th Circuit says yes, the 9th Circuit says no, and the Supreme Court doesn't take one of those cases?
Then yes is the law in the 10th Circuit, and no is the law in the 9th Circuit. That's right.
Oh, that's pretty amazing. All right, very last question. You work with your colleague Dave Kopel. Both of you have had lots of amicus briefs, or amici, is that how it's said? You write friends of the court.
Amicus briefs is fine.
All right. Yeah. And you guys have a good competition of who has been quoted more in Supreme Court rulings. I believe you were winning that race with an obscenely high amount for any legal scholar. How many times has your research or work been cited in a Supreme Court decision or dissent?
39, which I'm told is among the top 10% of all scholars in the country. By way of disclosure, however, I should point out that Dave Kopel has been cited by the federal appeals courts far more than I have. And of course, most cases end at the federal appeals level. So I'm not sure which of us is more effective here.
And if you get quoted in Supreme Court decisions 40 times, one more, Do you get a gift card? Is it? Do you get a free tour of the building? Do you get a punch card for coffee? What is it that you achieve?
Oh, I suspect I'll get a meeting with a Supreme Court justice and maybe some cotton candy.
Yeah, I'm sure you will.
Yeah.
Robert, thank you so much. People want to find out your work, go to thinkfreedom.org.
Yeah.
All right. Until next time, think freedom.
If you enjoyed that conversation, by all means, click one of these other great programs. We have the best conversations with the most fascinating Coloradans. And subscribe to our channel. Just click down below and hit that little bell button too. You don't want to miss a single show.